Hi, in today's episode of Business is More Exciting Than Any Game, I want to talk about a recent decision of the USPTO's Trademark Trial and Appeal Board involving a trademark application that had been filed for the trademark Purple Rain, and it had been filed basically to cover certain dietary supplements and energy drinks, things of that sort. It was filed by a company that had no connection with and no involvement by the estate of the famous performer Prince. And so the applicant had filed an application for the trademark Purple Rain for this energy drink or this dietary supplement. And because the estate of Prince protects its trademarks, the estate filed an opposition to the granting of that trademark with the U.S. Patent and Trademark Office, or the USPTO. A trial was held at the Trademark Trial and Appeal Board. Basically, the opposer, the estate of Prince, raised three different issues. One was that this proposed trademark for Purple Rain for an energy drink by a company that was not related to the Prince estate would be confusingly similar to trademarks already owned and registered by Prince or the Prince estate in different classes. Another claim that was filed, another claim that was raised by the estate of Prince, in addition to that this proposed trademark would be confusingly similar, was that it would dilute the strength or the value of the trademarks that the Prince estate already held. And then the third basis for opposing this trademark was that granting it would imply connection that would be false connection between this energy drink, Purple Rain, and the estate of Prince. Now, the USPTO's decision, the Trademark Trial and Appeal Board's decision that's part of the USPTO, really focused on the claim by the Prince estate that there would be a false connection with the estate if this trademark proceeded to registration. It had an expert witness that testified that they had done a survey that showed that 82% of respondents were familiar with the trademark Purple Rain, really in connection with Prince, and that over 66% of the respondents identified Purple Rain with Prince. So there was a strong connection between, in the minds of the public, between the trademark Purple Rain and Prince. Now, the company that was seeking to get a registration, a federal trademark registration for Purple Rain for the energy drink or the dietary supplements, raised the fact that there were existing trademarks that had been registered for Purple Rain or some trademarks very similar to the word Purple Rain for various goods, and that these trademarks were not owned by Prince or Prince's estate. There was, for example, one for coffee. There was one for garlic. There were a couple, or two or three, that were in the what you would call the food kind of side of goods, and they raised that as a defense and said, well, these items got these companies got registrations for Purple Rain or something similar to Purple Rain for a food type product. And so that just shows that we should be able to do the same. It's the same type of analysis that was the claim. So anyway, the decision from the Trademark Trial and Appeal Board was that there would be a false connection that would be created if this registration proceeded. And so the TTAB, the Trademark Trial and Appeal Board, basically said, no, you cannot get this trademark for Purple Rain for your energy drink or your dietary supplement. It went through the analysis on what creates a false connection between essentially what's a famous trademark and a trademark that would be that was proposed to be registered by someone else. Really, this case is interesting, but it also teaches entrepreneurs and business owners several important lessons. One is trademarks are valuable, and your business brand is valuable. Obviously, the estate of Prince would not be policing their trademarks and enforcing their trademarks if there was not a great deal of monetary value to their trademarks, including their trademarks for Purple Rain. It also teaches, number two, that the importance of policing your trademarks. You need to monitor what's called the official gazette to see when trademarks that might be infringing or potentially infringing on your trademarks are applied for. You need, if necessary, to file an opposition like the Prince Estate did in this particular trademark application and see it through in order to protect your trademarks. Now that's one and two of the important things to think about: the value of the trademarks, the importance of monitoring and enforcing your trademarks. This case also teaches that there are various ways that you can what things you can rely upon in enforcing your trademarks. One is there a false connection to your trademark? Another is, would a proposed trademark dilute, or would there be dilution to the value of your trademark, which was one of the things that was raised in this case. And third, is a proposed trademark confusingly similar to yours? So that's another thing. And also the Prince Estate raised the fact that not only did they have registered trademarks, but they had common law rights in this in this trademark Purple Rain. So that's just another basis for what you might claim is as a protection in the event that someone attempts to potentially infringe on your trademark. Finally, I would say that this case also points out the importance of protecting your marks in various classes. And it didn't appear that the Prince Estate had trademarks registered in the classification that this energy drink or this supplement was in, which was Class 5. And in fact, the company that was seeking to get the registration pointed out that there were already existing trademarks registered in Class 5 and dealing with foods. So that kind of made at least an interesting case and not a slam dunk necessarily, because there were some trademarks out there in the particular class that this applicant was seeking to register in. So if you have a trademark in a particular class that you're using it in, if there's any possibility you might that you might use it in another class. For example, if you have a service company, say you have a coffee shop or something along those lines, but you also sell T-shirts or coffee mugs or things of that sort, you may want to not only get your trademark registered in your primary classification. Let's say it's for a service business, and then whatever class that might be in your particular business, but you might also look into protecting your mark in other classes that are sort of ancillary to your business, such as T-shirts or coffee mugs or things of that sort. So that's another thing to keep in mind. All in all, this is a very interesting case. It points out, like I said, the importance of trademarks, the value of enforcing your trademarks, some of the bases that you can use to defend your trademarks, and finally, the importance of considering broadly the classifications that you register your trademarks in. Okay, that's it for today on Business is More Exciting Than Any Game. I hope that helps you in your business.